Okay, let's get started. It's 11:02. As additional people come, they'll just join in. My name is Tim Hayes. I'm the Executive Director of AIR CRE, and I want to thank all of you for attending the second in a series of town hall meetings AIR CRE will be hosting during the coming weeks. We will be emailing you information regarding those upcoming town halls, so be on the lookout for those emails. Before I introduce our speaker, Josh Geller, I just want to mention that the session is being recorded, and within the next 24 hours, we'll email you, and we will be posting that recording so that you'll have access to it, and you can share it if you need to with your colleagues. The emails we sent regarding this session mentioned that anybody who wanted to could send in questions regarding the CARES Act, which is what Josh will be speaking about today. And we received over 30 questions. Josh and I have gone through those and sorted them out so that he has what he needs to respond to those. He's going to speak for probably 25 or 30 minutes on a number of topics, 3 or 4 different topics that you can see there on your screen. So he'll be speaking about how can CRE businesses benefit from the small business loan programs? What are some of the hurdles to obtaining small business loans for landlords and commercial developers? What are the moratoriums and forbearance on evictions, foreclosures, and mortgage payments? And do any of the revisions to the tax code specifically impact CRE businesses? So he will speak about those topics, and then time permitting, we will get to as many questions as we can. We may not get to all of them, so I apologize in advance for that. You also have access to the chat box, as I see some people have already been making use of. If you have questions as we're going through it, put them into the chat box, and any that we already have not received, and again, time permitting, we will try to get some of those questions in the chat box as well. And then the other thing just to mention is Greenberg Glusker has taken a very active role in publishing information on the coronavirus and all of the fallout, all the legal issues around it. And they have some great information on their website. So if you're trying to find out more information, maybe something that wasn't covered last week when Lee Dressy spoke, or this week with Josh, you can go to their website and take advantage of all the resources that they have there. So now to introduce our speaker, Josh Geller. Josh is a litigator at Greenberg Glusker whose practice focuses primarily on entertainment and intellectual property litigation. He has significant experience representing studios, production companies, video game publishers, musicians, and other independent content creators. He also has significant appellate experience litigating before both the California Supreme Court and the Ninth Court. During the past 5 months, Josh has become an expert in legal issues brought on by the coronavirus and now serves as co-chair of Greenberg Glusker's Coronavirus Task Force. Josh earned a BA from Yale in 2010, a JD from Harvard Law School in 2013, and he is an avid Dodgers fan suffering serious withdrawals at this point. In fact, if the Major League Baseball season was going right now, it's likely you'd find Josh at Dodger Stadium tonight watching the Dodgers take on the St. Louis Cardinals. So with that, Mr. Geller, I will turn it over to you.
All right, thanks, Tim. Hello, everyone. So I saw some comments in the chat. I can't see you. Hopefully you can see me. It's a little, disconcerting talking into the void, but I trust you're all out there. So yeah, I think thanks for the introduction and the background. I think you mentioned that in the past 5 months, I've become an expert in the coronavirus stuff. It absolutely feels like it's been 5 months. Somehow it's only been about 5 weeks. And yeah, that introduction is correct. I am a litigator. I started getting into this coronavirus situation really just on my own before a lot of the legal fallout started coming about. And from there, we started getting the state and local orders, the shutdown orders and the stay-at-home orders, and then it escalated to the federal stimulus bill. So I've spent the last several weeks, 5 weeks now, basically immersed in that material and a lot of the legislative and regulatory reactions to the pandemic. So we're all learning this together. It's been a whirlwind little while. So today, and I'll say one of the primary kind of types of consultations I've been doing in the past several weeks has been with commercial real estate companies, different parts of the sector, because the fallout from the pandemic has just really impacted the industry from so many directions. I mean, businesses are obviously impacted, having to shut down. Tenants are getting hit, and then that's trickling up to landlords, developers, and everyone else. So today, we're going to talk about the main ways in which the CARES Act impacts the commercial real estate business. Unfortunately, the CARES Act doesn't really do that much that specifically targets the commercial real estate industry, but there are still a lot of impacts that it has, either some directly, but many more indirectly on the industry. So the first and biggest topic we're going to be talking about are the loan programs and the grants. I think the one folks are most familiar with, it's generally referred to as the small business loans, the SBA loans, and I'll get into that in more detail in a minute. You may have already heard the news that at least one of the programs through the SBA ran out of money as of either last night or this morning. And it's been kind of a frantic grab for everyone trying to get access to the program. What we're hearing, though, is Congress is still intending to or looking at further funding the programs, and there are some other loan programs that are still available under the CARES Act. So some of this may be useful right now for programs that are still ongoing, or may be useful in the coming weeks, because as we all know, this crisis isn't going anywhere anytime soon. So it would not surprise me to see more funding for some of the programs that have already been kind of tapped dry. And then briefly, I'm going to talk about two other issues at the end about the CARES Act. One of them is essentially what are the moratoriums, forbearances for federally backed mortgages or relating to federally backed mortgages. And then number three is I'm not a tax attorney, so I'm just going to flag at least one tax issue that is especially directed at the commercial real estate sector, just so you all are aware of that. And then we'll open it up for questions. We have questions about the CARES Act and a whole bunch more, so there'll be a lot of content on that front. So let's start diving into the loans a little bit. There are a number of different types of loans that are relevant here. The biggest bucket, which I mentioned a second ago, is been just referred to as the SBA loans, and that's referring to the Small Business Administration loans. That umbrella category of loans is actually divided between the PPP program, which is the Paycheck Protection Program loans, and then there are also EIDL loans. Oh, it's redundant. The L is for loans. So it's economic injury disaster loans. So the PPP is the one you've probably heard the most about. That's the one where funding has reportedly run out as of today. But they're debating in Congress, further appropriations up to $250 billion more for that program. And then the last group of loans I'm going to briefly talk about is a new program that was announced just at the end of last week by the Federal Reserve, which is the Main Street Lending Program. And that's still in its earliest stages. We don't have sample applications. We don't have the full guidance. As far as I know, certainly as of the last few days, lenders have not been accepting applications yet, but that's the next big one on the horizon. So to dive into the PPP loans first, and I'm going to talk at a high level how they work, but I don't want to get too bogged down in the details given the present circumstances relating to the lack of further funding. Originally, $350 billion were earmarked for these small business loans. And again, they're talking about allocating another $250 billion. So keep an eye out on that. Essentially, the loans are obtainable from private lenders, from banks. I'm sure many of you have already been talking with your lenders and either applied, and some of you may have already received money, although there are some significant hurdles to that that I'll be talking about in a second. The very basic eligibility rules, which come with some unfortunate asterisks, are that companies with 500 or fewer employees are eligible to apply, as well as self-employed individuals and independent contractors can also apply for themselves. Loan amounts are basically calculated with reference to your payroll. It's essentially you look at the last 12 months, calculate your average monthly payroll, multiply that by 2.5 times. So if you have a $100,000 monthly payroll, you could theoretically get a loan of $250,000 up to a maximum of $10 million. The terms for the loan, there's essentially 1% interest with a 2-year maturity. Principal and interest payments are deferred for 6 months. But the big reason there's been such demand for these loans is because there's a built-in forgiveness mechanism where the loan amount and interest can be forgiven in its entirety. The way that works is frankly still up in the air. So those of you who have received loans are going to need to keep an eye out, because there's going to be guidance we expect given out by the Treasury Department as far as how loan forgiveness is going to work. Because I've been, kind of diving into the details of this for weeks, and we've been asking some of the same questions over and over that we just don't have an answer to. But the basic way forgiveness works is, to the extent you use the loans on covered expenses, which are going to be primarily payroll, but also rent, utilities, payments of interest on mortgage obligations, and interest on other pre-existing debt obligations, those amounts may be forgiven in their entirety. Now, there's a couple clarifying points we've received about that. One is that not more than 25% of loan forgiveness can be attributable to non-payroll. What that means, say in reverse, is that in order to maximize your loan forgiveness, you need to spend 75% at least of the loan amount on payroll. And obviously that can be difficult, because right now a lot of companies are shut down. Workers aren't coming in, and people have other expenses that are piling up. So that can be a serious impediment to getting maximum forgiveness. There are also restrictions based on employee retention. The idea is you're supposed to get maximum forgiveness if you keep all your employees. The formula to determine that, however, is very complicated and something that's just going to need to be clarified in the coming weeks. The bottom line is that if you, for example, were to reduce your headcount by 50% during the relevant time period that's looked at, your loan forgiveness amount would be reduced by 50%. But that condition comes with its own exception, which is to the extent you had employee reductions from February 15th to April 26th. So we're still in that period. It's basically from around the time when the crisis started, this beginning of this situation, those reductions will not count against your forgiveness. You will not be penalized if you eliminate those reductions by June 30th. So that's raised a whole host of questions of what it really means to eliminate those reductions by June 30th, and how that calculation would work. What happens if you hire someone on June 29th? Is it just everything's wiped clean? We don't know. So the bottom line is, be on the lookout for further guidance on forgiveness. You're going to need to talk to your attorneys, talk to your accountants, because it's going to be a very payroll specific question, how you're calculating your loan forgiveness. But that's the basic gist of the PPP loan. I'm going to talk at the end of this segment a little bit about other hurdles that have come up specifically for the commercial real estate industry, essentially for being in this industry. So there are some serious problems there that need to be addressed. But briefly, the other type of loan available from the Small Business Administration are EIDLs. It's the Economic Injury Disaster Loans. Those you apply straight from the SBA. You go to their website, their .gov, and you apply there. These are essentially emergency relief loans. If you're unable to meet your expenses or other obligations as a result of the pandemic, this may be a good loan to take a look at. The eligibility requirements are a little less well-defined for the EIDL, but the kind of safe assumption is any eligibility restrictions that apply to the PPP loan likely apply to EIDLs as well. The big difference between the EIDLs and the PPP is the EIDLs are not forgiven. They're not grants. There is a portion that is forgivable, which is an advance that you may have heard about, where according to the CARES Act, as it was written several weeks ago, when you applied for an EIDL, you were supposed to, within 3 days, get a $10,000 advance that is forgiven no matter what, even if you get denied the loan. It's supposed to be free money, which sounded too good to be true and has proven to be too good to be true. I've heard from many clients that they have not been getting that money, not only not within 3 days, but just period. And the SBA has announced that they're actually capping that at $1,000 per employee. So you could still theoretically get up to that 10,000 number, but that's also a restriction. But the big change to the EIDLs was under the CARES Act. It says they're capped at $2 million, but the SBA just in the last, I think, week or so announced, actually, we're only going to be giving $15,000 per application. So 2 million down to 15,000, I'd say a pretty substantial difference. So the EIDLs helpful, certainly if you have immediate expenses that can't be met and you need that immediate relief, but it's not going to be a silver bullet for businesses by any means. And then the last lending program that's been announced, although it's not out in force yet, is the Main Street Lending Program that the Federal Reserve is rolling out. These loans are supposed to be available to small and medium-sized businesses, and medium-sized means up to 10,000 employees or revenues less than $2.5 billion. So presumably that covers quite a few companies and a lot more than the SBA loans covered. We don't yet know the full scope of the program. They're talking about up to $600 billion in loans. We'll see if that pans out. This is going to be like the PPP only in the sense that you apply directly to lenders. You don't apply to the SBA, or you don't apply to the Federal Reserve in this case. So the bottom line here is, because we don't yet have loan applications rolled out for this, and we don't know what all of the qualifications are going to be, if this is something that you may be interested in or you may qualify for, I strongly recommend people start talking to their lenders immediately. Those of you who have tried applying for PPP loans know how difficult it is to get the process going. It's been first come, first serve. It relies heavily on you having good relationships with your lenders and having lenders who can help you out. So I strongly recommend you start talking to folks, talk to your advisors, talk to your consultants about this loan. The Main Street Lending Program is not going to be a forgivable loan. But the initial terms we're hearing are that principal and interest payments would be deferred for a year. We'll see if that sticks. And something to be mindful of is that the loans would come with some restrictions on executive compensation, stock repurchases, and dividend payments. We don't have the full set of rules and regulations on them, but that's something to be mindful of. So those are the programs that have currently been rolled out through the CARES Act. But there are several big hurdles that folks in the commercial real estate industry have been facing in trying to get these funds. The first and the elephant in the room that we started with is, at least for the PPP loans, the money is not there anymore for now. So that's a pretty big hurdle. I'm not going to lie. So what we're hearing is that there may be more funding on the way. Again, there's a lot of pressure, I think, from industry groups and across the board for more relief. People are starting to see the writing on the wall that we could be in this situation for quite a while, and that things are not just going to snap back to kind of a rosy economic situation, even when some of the stay-at-home orders are lifted or relaxed. So I think there's going to be a lot of pressure and incentive for Congress or other sources to allocate more funding to the PPP program and others. So I would keep an eye on that. But beyond the questionable funding situation, there are two other big issues that I've been hearing from clients and people in the industry that really impact negatively the commercial real estate sector. So the first has been affiliation rules. Essentially, and this applies specifically to the small business loans. because the idea of the loans is that they're available to small businesses. So what's small? In this case, it's 500 or fewer employees. But the SBA had, prior to all of this, has always had very elaborate and frankly broad rules about corporate affiliation, which essentially is the question as to when are two corporations affiliated such that their employee numbers should be aggregated and counted together. So you can have a situation where you have one company up top, some kind of management company that owns hundreds of LLCs, that are maybe one-off properties. They own a whole, set of hotels throughout the country. And it may be that while any one entity has fewer than 500, when you aggregate across entities, you get well in excess of 500 employees. And that can prevent companies from being eligible for the small business loans. Now, the affiliation rules are complex and broad. So the SBA has issued more guidance on how they work. But the bottom line is it's going to be a very fact-specific inquiry for every business. If you're concerned about affiliation, you're going to need to talk to a lawyer, talk to at least an accountant or someone to go through, because you need to look at corporate, the kind of the organizing documents of the corporations, so your articles and those sort of things, because questions of, it's not just a binary of, okay, these two companies share owners, or these two companies, have some other kind of connection like that. It can be a situation where you have a minority shareholder, an investor, or a venture capital, fund that has some controls, for board controls, for example, or veto power over corporate actions, and they may have an entire portfolio of businesses that they have some control over, and that limited amount of control can be enough to mean that all of those companies need to get aggregated together. So we've been seeing it a lot in the venture capital space, and we've been seeing it in the real estate space too, where you have a number of entities that are affiliated under the SBA rules. So that's certainly a big hurdle to look out for. The second, and I think the most draconian restriction, and we got some questions about this issue because this is sort of a sleeper issue in a sense. It's not mentioned in the CARES Act. It wasn't discussed in any of the guidance that came out from the SBA, but there are pre-existing SBA rules that essentially say that passive businesses are not eligible for SBA loans. And there's pre-existing regulations that date back to 2019 defining passive businesses as including businesses owned by developers and landlords that are occupying their property. It includes businesses that are primarily engaged in owning or purchasing real estate and leasing it for any purpose. Businesses that fit that qualification are not eligible for small business loans. There's an entry that says apartment buildings are not eligible. What does that mean? Does that mean any company that owns an apartment building is not eligible? We don't know. So this has been a real sticking point for people applying because we've seen a lot of lenders getting skittish given that some of the guidance from the SBA has not been forthcoming and not been wildly clear. And they're afraid of lending in contravention of these pre-existing rules. So that, I think, is the biggest issue to talk about with your lender, talk about with your attorneys and your advisors to see whether you fit into these categories of passive businesses or whether there's some way to get around that to identify the portion of your business that may be substantial that is not passive business. To the extent you're actively managing properties, to my read, that shouldn't be, you should not be foreclosed from seeking small business loans. But we've seen a very, very broad application of these rules, and it's shut a lot of commercial real estate businesses out of the small business loan market. So that is the basic loan parameters and what the big hurdles are. I've been hearing from industry groups that they're talking with Congress. They've been lobbying and trying to get more clarity on these restrictions on real estate companies. In fact, there was new guidance issued by the SBA in the last week or so that carved out legal gambling, which had been restricted. And so, one could read between the lines and assume that there was some lobbying at work from the industry that got that clarification. So I think it's going to be important to keep an eye in the next weeks or months or however long it takes on whether there's any effort to clear up some of these rules around commercial real estate and open the door to more loans being offered to eligible real estate companies. So I want to move on then to two other topics. So the next topic is basically what the CARES Act says about moratoriums and forbearance relating to federally backed mortgages. I'll be brief on both this topic and the next topic because I want to get to everyone's questions as much as possible, and also because a lot of this is maybe superseded by local orders. I know we got a lot of questions about eviction moratoriums in the state of California, city of LA, county of LA, and so these moratoriums and restrictions from the federal government may frankly be moot compared to what's going on locally. But basically what the CARES Act is just focused on is situations involving federally backed mortgages. So that's kind of what's in their jurisdiction. So there's some mortgage forbearances that I want to flag for everyone. Multifamily borrowers, and so that's going to be 5 or more units, with federally backed multifamily mortgage loans, so Freddie Mae or Freddie Mac or Fannie Mae, they, to the extent they were current on their mortgage payments before all this began, so February 1st, they may request a forbearance for up to 30 days from their servicer with a possibility of 2 more 30-day extensions. So you're looking at least up to 90 days. And then for individual homeowners and multifamily landlords, it's 4 or less units in this case with federally backed mortgages. Those borrowers may be able to suspend their payments for up to 12 months. So these could be some very substantial forbearances. So to the extent you're dealing with a federally backed mortgage, take a look at these provisions. Talk to your people because that can be a pretty serious relief for a potentially extended period of time. Second, there are foreclosure protections. So for a residential homeowner or a multifamily owner, that's a 4 units or less property, a servicer of a federally backed mortgage loan may not initiate the foreclosure process or move for a foreclosure judgment or a foreclosure sale for at least 60 days. And that began March 18th. So that's almost 30 days ago. So at least for the next 30 days, no foreclosure proceedings can begin. Now, obviously, there may also be restrictions locally that extend that further, but that's at least the federal foreclosure protection. And then lastly, there's eviction moratoriums. If a landlord is the owner of a covered property, and that's going to be essentially a property that is insured or guaranteed or protected or assisted somehow by basically a federal apparatus, so the Department of Housing and Urban Development, Fannie Mae, Freddie Mac, things like that. If a landlord is the owner of one of those properties, that landlord cannot evict a tenant for 120 days. So from the date the CARES Act passed, so that would go essentially to the end of July. And again, this is going to crisscross with other eviction moratoriums. Obviously, the state of California has a very broad one, so this may kind of be moot to the extent that the crisis carries over for the next several, for at least for another month or two. And so the federal moratorium may just be, mooted in the sense that the statewide moratorium may be longer than that anyway. So those I just wanted to flag for you so you're aware of them if you're dealing with federally backed mortgages. The last issue I wanted to touch on, and this will be even more brief because I am not a tax lawyer, and as much as I've dived into all of this CARES Act and coronavirus related legislation in the past few weeks, I'm not going to pretend to be a tax lawyer, but I did want to flag one provision that kind of caught my eye as especially relevant for the commercial real estate space. And that relates to, it's actually a correction of what's been identified as a drafting error in the Tax Cuts and Jobs Act of 2017. And essentially what it does is it relates to qualified improvement property, QIP. And what that means is it's basically improvements to the interior portions of non-residential property So examples, if you're installing or replacing drywall or ceilings or mechanical, electrical, and plumbing kind of repairs or renovations to a non-residential property, that improvement property is now eligible for 100% bonus depreciation. It's being treated now as 15-year property for depreciation purposes, which is estimated to be a substantial windfall for commercial real estate, for property owners and investors. I've seen estimates that it's industry-wide a windfall of about 170 billion. I say windfall, it was what was intended by the original 2017 Act, and is really just a correction there. So this particularly, I'd say, impacts the retail, retailers and really restaurants, hospitality, a lot of industries that deal with a lot of these internal improvements. And the change is retroactive, so it applies to improvements as of installed or done as of 2018. So to the extent you've already paid taxes, you can talk to your accountants, talk to your tax lawyers, and figure out whether there's money you can go back and get, and then money going forward. So beyond that, there are obviously a host of other tax changes in the CARES Act. None that, to my eye, really specifically deal with the commercial real estate space. I'd say Greenberg Lusker, my firm, we have guidance on our website as far as all of the tax changes. So if you're interested in learning more about what the CARES Act did there, I'd encourage you to go visit our resource center and take a look. But for now, I think that was the one that I wanted to flag for everyone here. So with that, that's the end of what I had to discuss as far as the CARES Act, because as I said at the beginning, while it has impacts on the commercial real estate industry, for better or for worse, and in a lot of cases for worse, it seems not particularly targeted at helping the industry. And a lot of the pre-existing rules, especially under the Small Business Administration, really do negatively impact or preclude some of the benefits from flowing to the commercial real estate space. So with that, I think we can move to some of your questions.
Very good. Excellent, Josh. Okay, so we're going to try to move quickly. We have about 25 more minutes. I think we should be able to get to all of these. Some of them have some detail involved, so I'm just going to read through them right off of the sheet that I have. The first one is, and these first couple have to do with SBA questions. So the first one is, I spoke to two of my bankers regarding PPP and SBA bailout money, American Business Bank and Northern Trust. They both communicated that there is no money available for commercial property owners whose tenants have not paid rent. Instead, they told me that my tenants would need to get PPP loans and other bailouts, and that I would need to rely on collecting the rent due from my tenants. I told them that my commercial tenants are breaking their leases and vacating. Other tenants have told me that they will be out of business soon. It will be practically impossible to collect from them. These bankers had no answers for me. What would you do if you were in my position?
Yeah, this is a really tough question, and I wanted to start with this because I've been getting this a lot. We got some questions along these lines from listeners to this talk, but I've been having the same conversations with people in the industry and clients. And the answer is it's a very, very tough situation right now. So I think private lenders have been a little overzealous in reading these passive business restrictions to preclude basically commercial property owners from obtaining loans. I think there are a lot of businesses that do own property and maybe in many ways primarily property owners or developers, but also have substantial portions of their business that are more active and would qualify for the loans. But I think a lot of the lenders are, like I mentioned before, a little skittish about lending when the underwriting requirements are very unclear and lenders don't want to be sticking their neck out just to find out down the line that the SBA said, no, you shouldn't have done that. So I think until and unless we get more guidance or until industry groups, make noise and get the government to clarify these rules and the extent to which they really intend to leave commercial property owners just out in the cold, I think until then, it's going to be a tough situation. So the lender is correct in the sense that tenants likely have a much better ability to obtain relief from the government. Now we're dealing with a situation where the PPP loans have already mostly run out. And again, if you're dealing with tenants who are breaking their leases and vacating or who are themselves just going to go out of business, there are not a lot of good avenues available for solving that problem. So I'm tentatively optimistic the Main Street lending program may provide more benefit for the commercial real estate space because it doesn't come with a lot of the restrictions built into the Small Business Administration. And so hopefully that lending will kick into gear and provide opportunities for commercial property owners. But in the meantime, it's sort of the double whammy of not yourselves being eligible for government relief and at the same time having these eviction moratoriums and rent deferrals that prevent both residential and commercial property owners from pursuing legal remedies against their tenants. That really has left the industry a little bit out in the cold. So I think to the extent you have tenants that have any prospect of still being functional companies when we get out of this or as we start to emerge from this, you should be talking to them about whether there's ways to, agree to rent reductions in the short term that gets some money in your hand. Because, and I'll be talking about this throughout, we got a number of questions about this. The rent deferrals are just that, they're deferrals. Now, for a company going out of business or a company that's just, breaking their lease, they may not care that it's only a deferral. For them, it's permanent. But for any company that might be sticking around, it's worth pointing out that even if they get their rent deferred for 12 months, those 12 months are going to end eventually. And then all of a sudden they're paying double rent for an entire year because they got to catch back up on what's been owed. Maybe it makes more sense for both parties to agree to some, rent reduction and get some money now. But otherwise, keep an eye out on the Main Street lending program, and let's hope that, that program bears better fruit than the PPP did for the industry.
Very good. Next question. My SBA loan relief app was declined because I used a third-party property management company to manage my apartment complex. Do you know of any other way I can get any kind of SBA relief loans? I can't believe that all apartment owners who use a third-party management company are shut out from the relief that other apartment owners who self-manage can get.
Yeah, and so this is related to that issue, but I just wanted to touch on this specifically too, because again, this just comes down to, I think the rules are, excuse me, I don't know that the rules were intended for this situation. I read them as both very draconian, and I think a lot of lenders are being overzealous in applying them. This is sort of a misery loves company answer, but I would say if it's any consolation, I was speaking to someone, just the other day who owned an apartment and managed their own properties. So they did not outsource to a third-party property manager, and they were still denied the loan, even though they're a property management business. They're an active business with payroll, and by all reason, they should be eligible for the loan. They still got denied in a denial that I think was incorrect. But because the lender didn't want to stick their neck out and said, hey, look, the pre-existing regulations say apartments aren't eligible. It says, developers and people and lessors are not eligible. I'm not going to split hairs and say, okay, yes, this one that manages the property is okay, this one's not. And they just blanket said, no, we're denying all of it. So it's going to come down to relationships with lenders. Unfortunately, that doesn't do folks a lot of good now. You're stuck with who you got. I mean, you have a better chance of getting some of these loans if you have pre-existing relationships with your lenders. But the flip side of that is some lenders are going to be more aggressive in giving out these loans, and some are going to be more conservative. So talk to other folks in the industry, talk to other lenders, see what you're hearing, because not everyone is reading these rules the same way. But I know a lot of folks are. So there are absolutely a lot of property management companies that are getting screwed out of this situation. And I think that's the unfortunate reality right now.
Okay, good. Next question has a bit of an explanation before it. This has to do with the recourse, and the next few questions will have to do with the recourse landlords have given the eviction moratorium. Assuming a commercial tenant in the city of LA, is requesting rent relief on its business, but it still receives sublease revenue that covers a portion of its rental obligation to the landlord. The lease provides that so long as the tenant is not in default, it can keep the sublease revenue. But if it is in default, the landlord is entitled to receive the sublease revenue. The question is, understanding that there will be no eviction proceeding during the emergency, can the tenant be deemed to be in default for non-payment of its rent and receive a notice of such breach so as to permit the landlord to contact the subtenant and collect the sublease rent directly?
Yeah, so that's a great question, and I think we got a few questions along these lines. So obviously, when it comes to any of these questions, I want to include the caveat that you're going to need to review the specific lease in question, even if you're dealing with a kind of a form-style lease, and it's going to depend on the specific situation and the relationship between the landlord and the tenant. But generally speaking, what we're seeing with the rent deferrals and the eviction moratoriums, they're all very clear in City of LA, County of LA in general, that this is not an excuse for non-payment of rent. So to the extent that there are other obligations under the lease or other things that kick in when someone is in breach, I think the default recommendation, again, with the caveat that you'd need to look at your specific lease and situation, but that it does make sense to send a notice of breach and say, look, I get that, you're exercising, to the extent the tenant has sent a notice and said, I'm not going to pay rent because of, COVID-19, you can still respond and say, all right, we're recognizing that we're not evicting you, but you're still in breach. And here are the ramifications of breach. And in a lot of cases, I think the guarantee is a good avenue to look at in your particular situation, because to me, it makes sense that, okay, well, you may not be able to evict them. You may not be able to go after them. But if they're in breach, they're in breach. And to the extent there's a guarantor, that would be exactly the situation when that would kick in. And unless the guarantor has their own excuse for non-paying, I don't see any reason why they wouldn't be on the hook. So that's kind of my read of the situation. But again, you're going to want to look at your specific lease and specific situation. Okay,
and you have tenants in a number of different situations. Some who were late with their rental payments before the pandemic ever started. Others who are requesting now a deferral or waiving the rents altogether, and others who have very low lease rates already. What type of proof of hardship, if any, are landlords allowed to ask for?
Yeah. So, and I want to be careful here because there are a number of interlocking orders. There's City of LA orders, County of LA orders, and other unincorporated areas have different orders. So giving general advice is tough, and the orders are changing so much on really a daily basis. They're getting extended or there are changes. So you could do an entire talk on the kind of the rental forbearance rules, the deferrals, and frankly, that talk may be obsolete within 24 hours. You don't know. So I want to be careful there. In general, what we're seeing is that tenants are entitled to claim these rent protections and rent deferrals. Usually they have to give some kind of notice, and the landlord usually is allowed to request some kind of proof from them. There's some caveats. You're not allowed to harass them. You can't go be banging on their door every day, demanding, proof of hardship. But business, both commercial and residential tenants should be expected to have some kind of, either their work's closed, or if they're a business, they should be able to show, okay, our revenues have gone away. And a lot of the different orders list some of the documentation that tenants should keep and have to prove up. So I don't think there's anything wrong in general with asking for proof. And if it's some kind of, whether it's a letter from the city saying shut down, okay, that may be good. Or if it's just something like, here's our balance sheet, and you can see that our revenues have declined. So I do think it's reasonable to request some sort of substantiation. And as far as, the specific situations where you've got tenants who were late before, or tenants who have very low rent already, or people requesting reductions, again, it's going to be kind of something you need to decide on a case-by-case basis. If this is a relationship that has any chance of continuing once we start to get back to normal, I do think it makes sense to be discussing rent reductions and coming up with some sort of mutually, if not beneficial, at least survivable arrangement where you're getting some money now and they're not having to pay the full balance back at the other end of the tunnel. But again, for situations where people are just breaking leases and closing up shop, it's a very, very tough situation for landlords.
Okay, next question. Do landlords have the rights to exercise their rights and remedies under the lease, including but not limited to putting the tenant into default and breach, voiding rights to exercise options, charging late penalties and interest, and recapturing inducements?
Yeah, so that's a great question. And again, I don't want to get too kind of prescriptive where I'm talking about what's okay, just because it's going to vary both based on the applicable rent deferral ordinance, both in the city and the county levels, and also what your leases say and what the agreements are. In general, I think I would go into it with the mindset that it's okay unless there's some extenuating reason based on where you are or what's in the lease. It should be okay to put someone in breach and give some notice of that, and whatever consequences that has under the lease may still kick in, with the exception of you can't demand payment of rent if the applicable rent deferral rules preclude that. Wouldn't be able to pursue eviction for the most part, and most of the orders I've looked at prevent imposing late fees or penalties. So that's the one that I would say probably not. For the most part, in the jurisdictions I've looked at, you're not allowed to be charging late fees or penalties while rent is deferred. But things like like having recourse to a guarantor, or maybe they aren't able to exercise an option anymore because they're in breach. Those I think are very much on the table and something you should be looking at.
Excellent. Okay, so I've instructed my tenants to apply for the different stimulus programs that are out there, and I've told them that we will work with them. We won't evict them. There will be no late fees, and we'll give them 6 months to catch up once we get out of this. Is that did I make a wise decision?
Yeah, I think given the circumstances, frankly, I think some of the state and local orders may be more generous than that. So your tenants may actually be entitled to even more time to catch up after the pandemic is over. Again, I don't want to get into the specifics of that because it varies so much jurisdiction to jurisdiction and is changing on a daily basis. But the bottom line of no evictions, no late fees, and giving them time to catch up, that's pretty much what the state and local authorities are mandating anyway. So to the extent you can work out a deal with your tenants where you're agreeing to all of that and they're agreeing to some sort of rent reduction or working on it, I think that's for the best. There aren't really a lot of good alternatives. So the hope is really that we have situations where landlords and tenants are both able to work together because they're both planning to be functioning businesses on the other side of this. And those are the situations where it makes the most sense to be having constructive conversations and trying to work out deals. I know in a lot of situations that's not going to happen. You're going to have tenants who are just going belly up, and the landlord will be left holding the bag, and that's it's not a good reality, obviously, but that is the reality for a lot of people.
Okay, I have a signed guarantee of lease. How does this affect payment of the monthly rental when the tenant is claiming the 3-month waiver of rent, as he says he cannot pay? Shouldn't the guarantee come into this picture and the guarantors pay the rent? I think you just touched on that.
Yeah, exactly. So I think the answer should be yes. Again, it's going to depend on your specific situation, but I would definitely be considering looking towards guarantors in that situation.
Very good. I filled out the base rent reduction amendment form for what I thought was what I had agreed to with my restaurant bar tenant and gave it to him to sign. However, he is now refusing to sign it and says he doesn't have to pay the rent and I cannot make him because all the courts are backed up. Any suggestions?
Yeah, and so I'll just be quick with this because that's the same situation kind of we've been talking about. There's not a lot of recourse. I mean, unfortunately, the tenant is right in the sense that courts are not going to be handling evictions and unlawful detainers for quite a while, even when they open back up. And again, this is especially pertinent to me as a litigator. I have no idea when court calendars are really going to get back to normal. I mean, we all know if you've spent any time dealing with LA courts, especially, they were backed up before all this started. I mean, it was not, unlawful detainers you can get more quickly, but a lot of actions and breach of contract claims took a ton of time before all this started. Who knows what it's going to look like in a couple months. So I would say to the extent you can negotiate and talk with your tenant about a rent reduction and remind them that rent deferral is not permanent, with the caveat unless they go out of business. But and even then, there's bankruptcy considerations, of course. But generally speaking, I think a rent reduction for any business that plans to be a going concern in a couple months is a conversation folks should be having.
Okay. So a few more. Under an AR lease, If a tenant exercises an option to extend their lease, then stops paying rent before the option term commences, do they lose the option they exercised? And if so, what if they repay all rent owed before the option term commences? Then is the exercise option reinstated?
Yeah, I think that was a great question, and I wanted to answer it, even though my answer is, frankly, I don't know. And you'd want to. I know you mentioned the air lease, but you'd still want to look at the specifics of the situation. The lease and whatever amendments there have been, and the relationship between the landlord and the tenant. But I think it's a good question, just because I think this is what landlords who are feeling, frankly, a little powerless in this situation should be thinking about, is whether there are other provisions or terms in the lease that may come into play if there's been a breach. So you may not be able to get your rent, you may not be able to evict the person, but maybe you'd be able to look at, okay, well, they can't, once this crisis is over, they're out of here because the option term extension is ineffectual when they're in a state of breach. That may be a possibility. So I think it's just a great question, because that's exactly the kind of thing landlords should be thinking about and taking a look at. Obviously, you're going to want to consult with an attorney or whoever else to figure out if it really applies in your situation.
Okay. What is your best guidance for small tenants whose business has been severely impacted due to the prolonged shutdown? Of course, they would like the base rent to be waived, not deferred, but that may not be doable. Any rule of thumb as to when the deferred base rent should be repaid? Third quarter or the end of the year, or does it carry over until next year?
Yeah, I think this is just a tough one to answer right now. For those of you who saw Governor Newsom's press conference, whenever it was Tuesday, talking about what does the path forward look like, what does opening back up look like, and I'll just kind of, frankly, go out of topic here a little and say, I'm very interested in this coronavirus issue, not just from a legal perspective, not from a commercial real estate perspective, just from a human perspective. This is a really tough situation. Nobody can really project how this all looks. I commend everyone in this chat who has been abiding by the stay-at-home orders and making sacrifices, as we all have. This is just tough, and I think federal or statewide and local officials will be reevaluating in the coming weeks. Hopefully, we continue to bend the curve and we start to get a better timeline for when things open back up. As it stands, we just don't know when this situation is going to start moving in the positive direction. And then even then, it's going to be months after that kind of things start to return to normal. So I don't know that we can really make predictions as to how long rent deferrals should be expected to be in place and how long it's going to take people to pay it back. This is going to be a very, very tough. It's already been a very tough, month or so, and I don't see it getting a whole lot easier very quickly.
Okay, I'm going to jump into. We have a couple more, but I'm going to jump into the some that have been asked via the chat. And Josh, I'm hoping you have some information here. It says, with regard to 1031 exchanges, do you have any information on the recent notice issued by the IRS extending deadlines?
Offhand, I don't know that. I do know, actually, there's an attorney at my firm who's a 1031 wizard. So there may be guidance that we're pushing out on our website or have already pushed out that I may just not have seen yet. So that's Greenberg Glusker. You navigate there. We have a coronavirus resource center. But that's also something, feel free to reach out to me after this town hall, shoot me an email because I know exactly who would know the answer to that question.
Okay, just scrolling through. And you may have touched on this, but under the PPP is the mortgage expense limited, and that's in quotes, mortgage is in quotes, expense limited to mortgage payments on the business location, or does it also apply to home mortgages, especially for sole proprietors?
That is a good question. To me, that's a little bit more of a tax question. I think if I'm remembering correctly, I'm not 100%, a lot of the guidance has sort of said, if you are deducting it as a business expense ordinarily, probably it counts. So if you're working from home and you've been, for whatever reason, deducting your home mortgage, probably. But I think it's going to depend on your specific situation.
Okay. Do you know if real estate brokerage services qualify as in quotes passive business rules you were mentioning?
Yeah, I don't think anybody does. It depends who you're asking. I think if you're asking some of the more conservative lenders that we've been seeing, they would say, I don't want any, if it has the word real estate in it, I'm not going to touch it. To me, no way, that makes no sense. But there's no consensus of opinion about that. So my view is no, they would not be a passive business, but others are going to disagree with that.
Okay, this sounds interesting. Does the recent order from the California Judicial Courts precluding county courts from issuing eviction summons apply to both commercial as well as residential tenancies?
I'm actually not positive. I thought so, but I don't hold me to that. I've frankly been trying to keep up with all of the various orders, and I've lost track of which ones apply to both. So that may be a good topic for another roundtable, because, or a town hall, because frankly, there's just so many different crisscrossing orders.
Okay, and I think this will be our last one. We've got a couple minutes. What is the potential, and this is sort of a three-part question. What is the potential liability to brokers, owners, property managers for touring buildings during non-essential business closures? Why don't you answer that one first, and then I'll get to the other two.
Sure. Well, actually, if you don't mind, because I have the question, I can kind of summarize and put these all into one big ball, because this was a question that I wanted to address, because it relates to this essential business question and these non-essential business closures. It's an issue near and dear to my heart, because this is how I got started dealing with this coronavirus situation, was giving advice on the essential business closures. So I would say this is a very tough question if you're not sure about touring buildings and how leasing works, because there are conflicting state and local orders. So the LA City order was recently amended, and actually my firm may be putting out an alert about this shortly, to allow basically professional services necessary to assist in the permitting, inspection, construction, transfer, recording of ownership of housing are deemed essential businesses. And there are limited showings of residential properties that are being permitted under this order. It's not clear how that applies to the commercial space, but there has been at least some allowance for some of these essential obligations related to permitting, construction, and leasing to continue. So liability, obviously, there's potential liability from the state or the local authorities who could come after you and say, no, you're not an essential business. So you need to be careful. You need to consult with folks, talk to your attorneys to make sure you're not doing anything you shouldn't be. And this also overlays with questions of force majeure, which was the topic from last week's town hall with Lee Dressy, because there's now a gray area where you have some shutdown orders saying, no, you can't do this. You can't go do this permitting or inspection. Therefore, how do you complete due diligence on a property? How do you finish whatever you need to do to close the transaction? Versus some orders that seem to be allowing some daylight in there, saying, maybe you can do that. So now you got this situation where were people really prevented from consummating this transaction or not? And it raises a whole host of interesting issues. So if you have more questions on that front, I'd encourage you to take a look at the video from last week on the force majeure issue.
Very good. Okay, so we are right up to the hour mark. It's noon right now. Do you have any final comments, Josh?
Just briefly, I'd say this is a really tough time for the commercial real estate industry, and it's a really tough time for all of us. And I just, I encourage folks to reach out to me or whoever else to discuss some of these issues, and maybe we can find creative solutions. But more than anything, I'm encouraging everyone, stay safe, take care of yourselves, take care of your loved ones, and hopefully we'll see some more daylight very soon. Very good. And just a final reminder, we will be posting this entire session has been recorded. We'll be posting that and sending out an email to everybody in our distribution list so that you can get access to it that way. We'll be having additional town halls in the coming weeks, and we'll be notifying you about that. And then again, if you have other specific questions, you might be able to find some good information on the Greenberg-Glusker website. Josh, thank you very much for participating. Thank you, everybody who is on the call this morning, and we look forward to seeing you soon. Bye-bye. Thank you.